Hello friends, good evening. This is your friend Bhushan. I welcome you all to another edition of Daily News Analysis. In this important edition, we are going to discuss some important articles that were featured in the Hindu and Indian Express newspapers today. Particularly from the perspective of prelims, which is, our explain section, we are going to discuss four important articles, particularly the first one being RBI, dividends to government or surplus transfers, and how center is seeking to enhance dividends from RBI. That particular issue is important from the perspective of prelims as well as mains for you. When it comes to the second article, we are going to discuss very important alternative dispute resolution mechanism that is there, that is permanent Lok Adalats. So this particular article is important from the perspective of prelims. You may get questions on this particular topic in prelims specifically, and in mains particularly alternative dispute resolution and what are some other methods of alternative dispute resolution is also important issue when it comes to GS2. The third important article that we are going to discuss is about SC ending retrospective approvals or green environmental clearance. See, this particular judgment, recent judgment by Supreme Court is important. Just know it from the perspective of environmental impact assessment, that is part of your GS2 as well as GS3 to certain extent. So just note down the what exactly the Supreme Court has said in this particular judgment. At the same time, you must know what exactly are the stages, processes involved in environmental impact assessment. So we are going to briefly discuss EIA as well. The another important article that we are going to discuss is about US birthright citizenship hearing in US Supreme Court specifically. So we are going to discuss what exactly is this birthright citizenship in US and how India compares to the US citizenship provision, this particular provision. And so we are going to take a deep dive into the citizenship issue in Indian jurisprudence as well. When it comes to the main section, we are going to discuss very important article from the perspective of science and technology part and GS3 specifically as well. The article is named "If You Build, They Will Come." What exactly does this mean is it tackles the issue of India's programs that can attract foreign scientists or Indian origin scientists in foreign universities. The currently, due to the policies of the Trump government in US, we have seen the funding threats to very world famous institutions, and essentially India has to attract the manpower in those institutions. So where India stands, what are some provisions regarding that is important area for us. So stay tuned for this particular edition of Daily News Analysis. So the first important article that we are going to discuss is about RBI dividends to the government. So what exactly is the news says here is center seeking to enhance dividends from RBI. See, essentially RBI gives the surplus to the government under its economic capital framework. So we are going to see what exactly is this ECF framework. We are going to also discuss how under the RBI Acts, RBI can transfer this surplus to the government. Particularly this article is important from the perspective of economy, Indian economy GS3, but at the same time from the perspective of prelims, you must know what exactly is this ECF. So when it comes to the news itself, recently the Central Board of Directors of RBI has reviewed the ECF. So they have reviewed the ECF, Economic Capital Framework of RBI, which essentially what ECF does, it determines the risk provisioning and surplus distribution by the central bank to the government. So essentially, to what extent RBI can provide the surplus to the government. See, most of the time, this particular issue you must have seen many times in news. Why this particular issue is in news all the time is because government always seeks to have the investment, the capital, so that it can actually fund its own capital investments as well at the same time. So essentially, one source of income for the government is this RBI surplus, which essentially does not add to the fiscal deficit. So to manage fiscal deficit, these RBI surpluses are also very, very vital. And in recent years, we have seen the record amount of RBI surplus transfer to the government. Okay, so in this year itself, there is a news that estimated rupees 2.5 lakh crore to 3 lakh crore surplus being transferred to the government. for this fiscal year. So you can imagine what sort of impact the RBI surplus can have on government finances, the government budgeting in particular, because essentially it does not add to the fiscal burden of the government. It is the surplus income of RBI itself. So essentially, what exactly is this economic capital framework? So as I earlier said, it provides a methodology for determining the appropriate level of risk provisions and profit distribution under section 47 of RBI Act of 1934. So essentially, what exactly is this ECF does? It provides certain sort of guidelines, certain sort of methodology to determine to what extent RBI can keep some income as a risk provision and to what extent it can actually transfer the surplus to the government at the same time. So as per this provision, central bank is required to pay a balance of its profits to the central government after making provisions for bad and doubtful debts, depreciation in assets and contributions to the staff. So after the RBI's expenditure essentially, and also contributing for the risk factors associated, the remaining provisions, the remaining sort of income, RBI can transfer to the government. So that sort of framework, basic framework is given in ECF. Based on the ECF, the RBI normally transfers the dividend to the government every year. Generally, this is the yearly transfer. After setting aside the contingency risk buffer. So this contingency risk buffer is very, very important. So what exactly is this contingency risk buffer? It is a precautionary fund against a crisis that could hurt financial stability. So to what extent is this CRB maintained by RBI is essentially currently ECF suggests CRB at 5.5 to 6.5% of its total balance sheet and transfer the surplus to or dividend to the government. So out of the RBI's total balance sheet, 5.5% to 6.5% can be kept as contingency risk buffer and transfer the rest to the government. So this is what exactly is given in the economic capital framework itself. And most of the time the recommendation, these economic capital framework, there are frequent changes in these ECF as well, according to there are certain committees which are formed to actually revise these ECFs at regular interval of time. So you must have seen, in recent times we have seen the Jalan committee way back in 2018, which suggested some changes to the ECF. And now currently what government is demanding is certain changes again in this ECF framework, which was actually given way back in 2018 by Jalan committee on the recommendations of Jalan committee. And now the center wants to actually revise some of the terms under this ECF. So as I said, RBI surplus transfer to the government. In recent times, there are record amount of surplus being transferred to the government. So as I said, in 23-24, RBI transferred highest ever surplus of 2.11 lakh crore, and now it is estimated that more than this amount is essentially going to be transferred to the government as a surplus. So what last year, particularly when last year 23-24, what this 2.11 lakh crore did for the government. So essentially, as I said, government can compensate its own expenses with this transfer. So you can see here, the graphics here shows how government can or have actually spent this RBI surplus. So spending on capex to Manrega to total subsidy, pension bill, government can utilize the surplus any way it wants to certain extent. So what are the advantages when it comes to the surplus transfer? These are more flexibility. There is more flexibility to the government. Government, according to its own fiscal priorities, can spend this money, the surplus transfer, and there are no fiscal deficit restrictions under the act. Improve liquidity condition. As I said, it obviously improves the liquidity condition in the system with higher surplus transfer to by the RBI. Supports government spending on infrastructure, social programs, economic developments, compensate for potential shortfalls in tax buoyancy and other revenue sources. So these terms are also important, tax buoyancy. So what exactly is the meaning of it? you just go through it briefly. Important term from the perspective of prelims here. Okay, what are some issues? We have seen the advantages of this surplus transfer, but what exactly is the issue with this surplus transfer? It reduces RBI's buffer against externalities. So see, we have seen, changing scenarios over the period of time. We have seen the COVID, now the tariff threats. So considering all the external risk factors, this reduces RBI's risk buffers to a certain extent. So that's why, there are frequent revisions to ECF as well. So this is one of the issues when it comes to RBI transfer. Affect autonomy of RBI. To a certain extent, there is always pressure from the government on the RBI to, transfer more surplus, because most of the time, government actually spends more and more on the capex, on, many time other many other priorities of the government. So, but at the same time, it can create inflationary situations as well, because it essentially fuels the government expenditure to a certain extent. As I said, there is always a demand for review of ECF. So ECF was last reviewed in 2018 according to the committee headed by Bimal Jalam. As I said, it was last actually reviewed way back in 2018 by under the recommendations of Bimal Jalan committee. And in that committee itself, there was, contingency risk buffer, which was suggested to be between 5.5 to 6.5%. So again, now the government is demanding the review of ECF again. So, this is it when it comes to ECF. But let's see what about the Forex Reserve. There is news today about India's Forex Reserve as well, in the Hindu newspaper particularly, on the economy page. So currently India has more than $600 billion of Forex Reserve. But these Forex Reserve levels keep on changing, week by week. We have seen the government, particularly on the RBI website, you can see week by week data of this RBI reserves, and essentially this data has been taken from that website directly. But when it comes to Forex reserves, what are the components of Forex reserve? There is foreign currency asset, there is gold, there is SDR, and there is reserve position in the IMF. These four components are actually involved in the total Forex reserve composition. You can see the amount contributed as well. So just remember the sequence, chronological sequence particularly, of these reserves under the Forex. So very important from the perspective of prelims. This data point is very, very vital. This is the practice question for you. Just comment your answer in the comment section. When it comes to next article, the article itself says the permanent Lok Adalats not functioning in Rajasthan 16 districts. See, per se, this article is not that much important from the perspective of prelims, but the terms here are important. For example, Lok Adalat. Lok Adalat, particularly, what exactly is this Lok Adalat? What are the provisions associated? This is very important area when it comes to prelims. So we will briefly discuss what exactly is the Lok Adalat. But before it, about the news, the news says that permanent Lok Adalats are not functioning in as many as 16 districts of Rajasthan due to want of extension of tenure to their presiding officers and members. So many times, this is the issue with Lok Adalats. Particularly most of the time they are not functioning. Why? Because of the lack of proper manpower, proper training to the manpower at the same time. Proper infrastructure availability is also an issue most of the time as well. So essentially, there are a lot of issues when it comes to Lok Adalat. But what exactly is the Lok Adalat? Lok Adalat are a type of ADR, alternative dispute resolution. See, just comment in the comment section what are some other methods of ADR. Very important from the perspective of prelims, knowing what are the other methods. And we have seen the emergence of e-ADR as well. So many times, online e-governance related jurisprudence in this regard as well. Okay. So what exactly is this Lok Adalat? It is a form of ADR serving as a forum for amicable settlement of disputes, both those pending in court and those at the pre-litigation stage. So, both pending in the court and pre-litigation stage cases can be filed in the Lok Adalat. But what is the legal status? They are legal, obviously. Lok Adalats have been given statutory status under Legal Services Authority Act of 1987. So, it is a statutory body under the provisions of Legal Services Authority Act of 1987. What is the composition of the Lok Adalats? Generally, they are typically presided over by sitting or retired judicial officers as the chairman with two other members, often a lawyer and social worker. So, essentially, the composition is not that much difficult to understand. Retired judicial officer presides over it. There are, there can be two or other members, particularly often a lawyer and a social worker. So, this is, the provision. What about the decisions of Lok Adalat? The decision is deemed to be decree of a civil court and is final, binding on all parties. So, the decision of Lok Adalat are binding on all parties and no appeal against such award lies before any court of law. So, no appeal is allowed under the jurisdiction of Lok Adalat. While direct appeals are not permitted, an aggravated party can approach the High Court through writ petition. So, aggravated party can directly approach High Court through writ petition under 226 and 227 of the Constitution, Article 226 and 227 of the Constitution, if they believe the Lok Adalat award was obtained through fraud or other irregularities. So, essentially, direct appeal to the lower judiciary is not allowed, but the aggrieved person can go directly to the High Court and file the writ petition under Article 226 and 227. What about court fees? There is no court fee payable when matter is filed in Lok Adalat. This is very, very vital. Okay, particularly from the perspective of prelims, knowing these facts about Lok Adalat is important. There are no court fees. If a matter pending in the court of law is referred to the Lok Adalat and is settled subsequently, the court fee originally paid in the court on the complaint petition is refunded back to the parties. This also provision is important. Okay, so essentially there are no fees, court fees particularly, which are there in Lok Adalat's jurisdiction. Role of members of Lok Adalats. The members of Lok Adalats can only persuade the parties to come to a conclusion for settling the dispute outside the court in the Lok Adalat. They shall not pressurize or coerce any of the parties to compromise or settle cases either directly or indirectly. Okay, so this is about the role of members, how they can behave when it comes to Lok Adalats. What about the types of cases the Lok Adalats generally dealt? So, essentially, you also must remember Lok Adalat also deals with criminal offences, but criminal offences which are compoundable, criminal offences that can be resolved. Okay, the criminal offences which are compoundable can be filed in Lok Adalat. So, essentially, Lok Adalats can preside over both civil cases as well as criminal cases. At the same time, Lok Adalat can have the jurisdiction over land mutation cases, family disputes, land acquisition cases, non-sub judice cases, motor accident, forest encroachment. This particular provision here is very, very important from the perspective of prelims. Just know that Lok Adalat can resolve these sort of cases particularly. But what exactly is this permanent Lok Adalat? So, permanent Lok Adalat operates as an institutionalized, specialized version of the Lok Adalat system. The main purpose of permanent Lok Adalat is to address all disputes that emerge from public utility services, including water supply, electricity distribution. See, most of the time, many times permanent Lok Adalats are often temporary under various state jurisdictions. But permanent Lok Adalat, when it comes to permanent Lok Adalats, they will be there to address the issues and complaints when it comes to public utility services. So, in many jurisdictions you have permanent Lok Adalats as well. What is the difference between say regular Lok Adalat and permanent Lok Adalat then? Jurisdiction, as well as I said, deals with broad spectrum of cases including civil disputes, compoundable, criminal cases, family, consumer and labor disputes. Permanent Lok Adalats specifically addresses disputes related to public utility services. This is the main difference. Permanent Lok Adalat specifically addresses disputes related to public utility services. You must remember this particular fact here about the jurisdiction. difference between PLA in the sense permanent Lok Adalat and regular Lok Adalat. Duration and establishment, most of the time Lok Adalat is ad hoc in nature, permanent setup in PLA, permanent Lok Adalat. Okay. Scope of cases, handle various types of cases like civil, criminal, but permanent Lok Adalats, as I said, limited to public service related utilities and disputes surrounding those issues. This is the practice question based on the article that we just discussed. Just comment your answer in the comment section. This is the PYQ which was asked in the UPSC. So, you will have the question on alternative dispute resolution in prelims often. So, at the same time, just go through the provisions of Gram Nyayalayas Act as well. So, Gram Nyayalayas are also there. We have seen the provisions related to arbitration, conciliation, mediation, and the act surrounding that as in our earlier DNA discussions. So, knowing these particularities when it comes to ADR is also very important part of prelims. So, the next important article that we are going to discuss is about SC's recent verdict on what? On retrospective green clearances. And SC declared that retrospective green clearances are plainly illegal. So, this particular article here is important from the perspective of means mainly, but at the same time from the perspective of prelims, you must know what exactly is EIA, what exactly are the recent notifications surrounding EIA as well, and the controversies surrounding that to a certain extent. So, essentially in the current scenario, what the Supreme Court did is Supreme Court terminated the grant of ex post facto or retrospective environmental clearances by declaring them as grossly illegal. So, essentially what the SC judgment did here, it struck down the 2017 notification and 2021 office memorandum of the center which recognized the grant of ex post facto ECs, environmental clearances. So, ECs already granted till date under 2017 notification and 2021 office memorandum notification would be unaffected by the judgment, but ex post facto after these notifications, the clearances given to the project are essentially illegal now. So, what SC held is this particular ex post facto EC is derogation of fundamental principles of environmental jurisprudence and is violation of environmental impact assessment notification of 1994. The EIC notifications warrants a careful application of mind besides a study into likely notification warrants of consequences of proposed activity of the environment. So, essentially now the ex post facto clearance would are illegal to a certain extent. Okay. So, this is the news. See, per se this news is not that much important from the perspective of prelims, but you must know recent Supreme Court judgments when it comes to environment, very important from the perspective of prelims. So, many times we have already discussed Supreme Court's various environmental related judgments from MC Mehta to recent times we have seen right to clean environment related judgments under Article 21 as well. We are not going to discuss these particular judgments and jurisprudence here, just go through them briefly. At the same time, Supreme Court or rather judiciary has given many doctrines, for example, polluter pays, precautionary principles. All these principles are very, very important. Just go through them briefly here, very important from the perspective of prelims as well as mains. But what exactly is this EIA, environmental impact assessment? So, it is important management tool for ensuring optimal use of natural resources for sustainable development. So, from the perspective of sustainable development, EIA is very, very vital. What exactly is this EIA? What exactly is EIA does is it actually assesses the impact of the proposed project. So, to certain extent, it takes a 360-degree view of the future impact of the proposed project and actually assesses the impact on the environment and accordingly it recommends the potential of the proposed project to the ministry directly. Okay. So, essentially it was started way back in with the Damodar River Valley project in 1978-79. The scope has subsequently enhanced to cover other development sectors such as industries, thermal power projects, mining schemes, etc. So over the period, we have seen the expansion of EIA. So as I said, EIA procedures varies widely from one jurisdiction to another. That is there. There is no single procedure. There are certain state level and departmental level notifications regarding EIA at the same time. So what exactly is the purpose of EIA? It actually tries to seek transparency, certainty, participation, practicability, flexibility, cost effectiveness, credibility and accountability. See, these terms are very, very important, particularly when it comes to mains. You will have the question on EIA. So apart from the purpose, you must know when it was started. At the same time, some projects and EIA related issues you must know. EIA, recently we have seen the EIA notification of 2020. The rules under it are controversial. We are not going to discuss those rules here. So this, you must know the EIA processes. What are the processes involved in environmental impact assessment? You must draw this particular diagram when it comes to EIA question in mains. Okay. So what is the first step? It is screening and scoping. Then you have assessment of environmental risk. Then you have mitigation. Then you have decision making, and finally monitoring. So just remember these 5 steps under EIA, very, very important from the perspective of mains particularly. This is the practice question for you. If you understood the article correctly, you will be able to answer this question. Comment your answer in the comment section for this particular question. The next very important article that we are going to discuss is about US birthright citizenship. This was, in detail discussed under explain page of Indian Express. So very important, you must know the comparative aspect of citizenship when it comes to US jurisdiction, when it comes to Indian jurisdiction. So currently what has happened is, after the Trump through his executive action ending the birthright citizenship clause, the 14th amendment of the Constitution of United States, various organizations challenged the executive action in the various district courts, federal courts in United States, and many courts actually blocked the executive notification, the executive decision by the Trump administration. And Trump administration actually challenged this particular block in the Supreme Court, and now the US Supreme Court is hearing this petition of the government, Supreme Court of the US government, for unblocking of the executive action. So what exactly is this executive order? What exactly Trump says? Trump calls it crackdown on birth tourism. Most of the time what happens when it comes to United States, many times US has birthright citizenship. What does it mean is, anyone born on the US soil becomes US citizenship naturally. Okay, whether his parents are legally living in the US or illegal immigrants, doesn't matter. Okay, essentially the person born on the US soil or any US jurisdictions is considered US citizen. So many times what happens, whenever the illegal immigrants or illegal aliens, the Trump calls them, whenever they give birth to the child, essentially that child becomes the permanent US citizen. So from the perspective of staying in the US, particularly this child becomes important source of permanent residency in US, because until the child becomes legal age, there has to be caretaker, and these mother and father becomes his or her caretaker. So in that way they can get the permanent residency until the person comes of a legal age, because the person born is US citizen. Why? Because under the 14th amendment of US Constitution, anyone born on the US soil can be considered as a US citizen directly. So essentially birth tourism is stopping the birth tourism is the primary focus of the Trump administration behind this executive order, which was blocked by multiple federal courts. So what exactly is this birthright citizenship? As I said, anyone born on the US soil under the 14th Amendment of the US Constitution is considered as a legal US citizen. What amendment states is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the states wherein they reside. So essentially, anyone born on the US soil becomes the US citizen naturally. There is Immigration and Nationality Act of 1952, which has similar provision, which defined citizens with similar language as 14th Amendment. So essentially, what is the provision in the original US Constitution? When it comes to original US Constitution, which was ratified way back in 1788, the concept of natural born citizens in Article 2 is there. Although this term was not defined, the Constitution framers likely meant it to include both jus soli for persons born within the country. This jus soli term is important. What does it mean? Essentially, for persons born within the country, and jus sanguinis, jus sanguinis, jus soli. Jus soli, permanent persons born within the country. Jus sanguinis for persons born outside the country to American fathers. Both of them are considered natural born US citizen under Article 2 of the original US Constitution, which is of 1788 origin. Okay. What about, this is about US birthright citizenship. What about birthright citizenship in India? What are the provisions regarding that? So Article 5 under Indian Constitution states that every person who was born in the territory before the commencement of the Constitution shall be citizen of India. So essentially, before the commencement of the Constitution, anyone born before it can be considered as a natural born Indian citizen. Subsequently, Parliament enacted Citizenship Act of 1955, which provided birthright citizenship under Section 3 to every person born in India on or after January 26, 1915. So essentially, if someone is born, say, post January 26, 1950, which is the commencement date of our Republic Constitution itself, the Citizenship Act of 1955 gave the opportunity to such persons and it provided the birthright citizenship to such persons. There was an exception only for children born to an envoy of foreign sovereign power who is not a citizen and children of enemy alien. There are exceptions under that act. So essentially, but what happened in 1986, Parliament amended the act to address the entry of migrants from Bangladesh and Sri Lanka and some African countries. So in 1986, we have the change in the Citizenship Act, and post that, we have all children born after the amendment came into force would only become citizen if either of the parents were Indian citizens, marking the end of birthright citizenship in India. So until 1986, we have the birthright citizenship in India under the Citizenship Act, under the Article 5 of the Indian Constitution, but post 1986 amendment to address the issue of illegal migration in the Northeast, particularly, the amendment was introduced in 1986, and related developments you already know, at the Assam Accord and all those things. We are not going to discuss those issues, but post 1986 amendment, we have the end of birthright citizenship. Now, what is the provision? Essentially, if the child is born to the parents who are both or either one should be Indian by citizenship, so that they can be considered as Indian citizen. In 2003, the act was amended again to effectively state that child would not become a citizen at birth if one of her parents was an illegal immigrant when she was born. So again, in 2003, we have that change. Now, what exactly is the provision is both parent must be Indian citizens. Then only the child can be considered as a citizen of India. Okay, not if one parent is found to be illegal immigrant, the child born is also considered as a not citizen of India. It is considered as an illegal person, okay, illegal entity in Indian jurisdiction particularly. So these are the constitutional provisions from Article 5 to Article 11 of the Constitution. Just go through them briefly from the perspective of prelims, very, very important. This is the comparison chart of US and India when it comes to citizenship provisions. So, type of citizenship, dual citizenship, acquisition by birth, descent, all these parts are very, very important from the perspective of prelims. Go through them, very important. Just, know each and every provision when it comes to citizenship, because citizenship is often in controversy in news part. Okay, this is the practice question for you. Just comment your answer in the comment section for that particular question. So in the decoded section, we are going to discuss very important article from the perspective of GS3 Science and Technology particularly. The article is about how India can attract the scientists which are affected by fund crunch in the US universities. So very important from the perspective of mains, you must know what exactly is happening in the US, how India can take this opportunity positively for enhancing our own research and development related infrastructure, research and development related ecosystem in India. So currently there is an erosion of scientific infrastructure in the US. Why? Because the Trump administration is actually giving the funding threats to US universities. We have in recent times we have seen the Harvard versus US Trump administration in particular issue, where Trump administration cut billions of dollars of funding from the US research funds. So essentially, at the same time, there is threat to international students as well. We have seen the visa restrictions, arrests, and actually deportations in that regard. So considering all these factors, there is going to be exodus from the US universities of scientists. So India has good opportunity to attract this talent pool to India itself. So at the same time, there are competing nations which is jockeying for attracting this talent. For example, France is their safe space place for science. Under this, they are actually, there is legislative proposals where they can give the refugee status directly to these scientists. So there are, many times these European nations are trying to attract the talent that is fleeing the US jurisdiction, particularly US universities particularly. How India can leverage this particular issue now is because India has the comparative advantage here. There is a strong pool of Indian origin scientists in the US. Indian diaspora dominates the list of laureates. Many times Indian diaspora flourishes in outside universities. There is a growing domestic infrastructure like IAS is there, IITs are there, IIMs are also there. We have very great institutions in India itself. India has both environment, money, and the current movement offers the country a historic chance to replenish and enrich its knowledge economy. So knowledge economy term is again important. So essentially this is going to define India's century going forward. So essentially, what are the current schemes which are operational by the government to attract the talent now is essentially the first scheme being Visiting Advanced Joint Research Vajra scheme. So Vajra, this particular scheme is important from the perspective of prelims, means you must know what exactly is the scheme does. So this scheme is to bring overseas scientists and academicians, including non-resident Indians, overseas citizens of India to India, work to work in public funded institutions and universities for a specific period of time. So under the Vajra scheme, it is trying to attract NRI, OCI scientists which are working outside so that they can come to India, do the research here. This scheme offers adjunct visiting faculty assignments to oversee scientists, including Indian researchers, to undertake high quality collaborative research as well. There is another scheme called Vaibhav Fellowship. What exactly is Vaibhav here? Vaishvik Bharatiya Vaigyanik Fellowship, Vaibhav scheme, Vaibhav Fellowship. So it envisages a collaboration between scientists of Indian diaspora with Indian higher education institutions, universities, and public funded scientists. So essentially, Vaibhav Fellow would identify an Indian institution for collaboration and may spend up to 2 months a year and maximum of 3 years. So they can spend up to 2 months to maximum of 3 years in India doing under this fellowship. So these two schemes are very, very vital. Currently, they are operational in India. There are some other schemes as well, like Ramanujan Fellowship is there. There is Ramling Swami Re-Entry Fellowship. There is Biomedical Research Career Program as well. There is, technologist of Indian origin in Indian Research Laboratory. That scheme is there. Indian Research Associateship Scientist Pool scheme is also there. So these are some other schemes. schemes. Just remember 1 or 2 schemes here, just from the perspective of means, that is enough. Okay, so there are schemes under which the government is trying to identify the talent which it can attract to India itself, so that our own scientific economy, the knowledge economy flourishes. So currently, currently India spends less than 1%, around 0.6% of its GDP on R&D, and this is very low when it compares to OECD countries. For example, Israel almost spent 4% of its GDP on the research and development funds. Particularly, India's rival like China also spends around 1.5 to 2% of its GDP on the research, R&D particularly. So in that regard, India lags behind. So we have to increase our research and development funding. At the same time, the current opportunity presents us golden chance to attract the good talent from outside to India to work in India, so that they can contribute to our own India story. So what are some strategic recommendations in that regard? Bridge funding for abandoned projects. India can give bridge funding. India can have institutional incentives like Vaibhav and Vajra into full steam, and offer startup grants, lab space and IP rights. There is, role of philanthropy as well. So oftentimes this philanthropy is often ignored part. Indian philanthropy report of 2025 suggests that 1.31 lakh crore spent in 2024 on philanthropy. So some of it can go to science and technology field, research and development field as well. Leverage CSR, family philanthropy, etc., etc. So there is an opportunity for philanthropy, science-based philanthropy, to grow in India in this regard. So in conclusion, we can say that the confluence of geopolitical disruptions and India's scientific ambitions presents a historic inflection point. For India, it is an inflection point. To actualize its vision of becoming a global knowledge superpower, India must adopt bold structural reforms in institutional funding and diaspora engagement. Science is global, so must be our policy. So if India has to become a scientific superpower, now is the chance it can attract global talent, so that it can become global superpower in science, R&D particularly. Why? Because the science is becoming global. India has to have move away from its tunnel vision to actually identify this particular opportunity and take it with both hands. There are certain issues when it comes to research ecosystem in India as well. There are certain gaps, like, as I said, lack of proper funding mechanism. We have seen many bureaucratic hurdles in that regard as well, and the quality of research, those issues are also there. But considering India's own sort of obligations now, we have to take the opportunity head on now. So essentially, so that India can become a developed country by 2047 based on the knowledge economy front as well. So this is the practice question for you. We have seen the PYQ in this regard earlier as well. So this is it from my side. Stay tuned for another edition of Daily News Analysis tomorrow. Thank you.